Hi everyone, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Today, I'm continuing the set of videos that focus on how marriage and divorce affect estate planning. Marriage gives spouses certain legal rights. It is important to be aware of what comes along with marriage and what does not. In this video, I'm going to talk about how death of a spouse affects one's estate plan. Currently in North Carolina, when a spouse dies, the surviving spouse can make a claim against the deceased spouse's estate for the value of up to $60,000 of the deceased spouse's personal property, meaning individually owned vehicles, financial accounts, and household items that do not automatically pass to the surviving spouse upon death of the first to die, such as through joint accounts and property owned joint with right of survivorship, and financial accounts with the surviving spouse named as the designated beneficiary. This claim is called a spousal year's allowance. If you die without a will or estate plan, then the North Carolina intestate succession statutes determine how your estate will be distributed. The surviving spouse will receive a portion of the deceased spouse's estate depending on the deceased spouse's family structure at their time of passing. For example, currently, if the deceased spouse has no children and no parents living, then everything passes to the surviving spouse. However, if the deceased spouse has a living child or children or has a parent still living, then the surviving spouse only receives a portion of the estate, and the living child or children or the living parent or parents will receive the other portion. So, if you are married and have children or your parents are living and you want everything you own to go to your spouse if you die, then you better contact me and get an estate plan in place. Also, something to note is that if you die with a will or estate plan, the surviving spouse can still make a claim against the deceased spouse's estate if they are left with less than the statutory amount they are entitled to under North Carolina law, even if the deceased spouse's will or estate plan says otherwise. This claim is called an elective share, and the statutory percentage the surviving spouse is able to claim of the deceased spouse's estate is based on the length of marriage. So, if you want to leave less to your surviving spouse than the statutory amount they are entitled to under North Carolina law, such as if you are a blended family and want the majority of your estate to go to your children prior to the marriage, then you better contact me to get an estate plan with a marital agreement in place. We call the marital agreements togetherness agreements because both spouses will work together to provide trust and security for both of you in accomplishing your wishes. All right, that's it for today. I hope you liked this video and found it helpful. Please share with anyone you think needs to hear it. Again, I'm Julia Walker, a North Carolina estate planning attorney, here to help you understand why it is important to plan for your life and legacy. Have a great day.